All right, this is D483347, D483463, T150132, and T150120. Counsel, if you'd like to make appearances.
Mr. Honor, thank you. Shell Mercer, bar 6742. I am appearing unbundled on behalf of plaintiff Diana Buchele, who is here with me today. Buchele, Diana Buchele.
Okay, and good morning. And counsel, if you'd like to make an appearance.
Sure. Carrie Milner, 9869, with the defendant, Tom Buckley, who's also here.
All right, and good morning also. All right, if you want to have a seat here real quick. This case was transferred to me. I believe there was a stipend order, and I'm assuming it was to consolidate the cases that was logged out. I'm assuming at this point that the lower case number, the D483347, would be the controlling case, that anything filed would be filed in that case at this point, that we wouldn't file anything in the newer case number. I don't know if the stipulation in order considered that the complaint for the newer case would just be considered the answer in this. If that were the case, that seems to make sense. I still do not have a financial disclosure form from your client.
I do have one, Your Honor.
You can file that in open court if you like.
It is out of order, however. The pages are out of order.
Is there any way to put them back in order before we file
Yes,
it?
if I can just borrow your stapler really quick.
Sure.
Thank you. May I approach?
Yes.
Thank you. I did. I was clever enough to have emailed it to opposing counsel last night, so she actually has one. Thank you.
All right. I'm going to have a discussion, not necessarily with counsel because they're in my department all the time, but with the two of you, that I might put forth on the record my expectations in this case, in this divorce action. We do not have any children in this case, nor do I think children are going to be a possibility in this case. I don't see any reason why the two of you have to be in the same physical proximity. There is no reason for the two of you to be anywhere near each other. This court is going to put a no contact order. The two of you have filed temporary protective orders against each other. The two of you are making allegations regarding the conduct of each other. What I would tell you, I'm just straightforward. I'm not for game playing. I'm not for people trying to protract litigation. If one of you ultimately tries to make this a very difficult, long, expensive case. Whoever that does that, not only could you potentially pay for your attorney's fees, but you could pay for the other attorney's fees. The court makes a determination on attorney's fees. If somebody comes into court and makes allegations that are not supported by the truth, or that appears somebody's misrepresenting themselves to the court, or flat out lying to me, I will take that into consideration, and there may be a number of issues that it's just the two of you, and that I'm going to have to make decisions regarding who do I believe is more credible. That's why today I'm going to put the two of you under oath as to pleadings that you have submitted to this court. I'm also going to put a behavior order in place. What a behavior order means is the two of you, either personally, through another person, family member, friend, anybody on the planet, you cannot harass, you cannot bother. The two of you are represented by counsel. At this point, you should work through counsel. Your attorney's here today in an unbundled capacity, ma'am. However, your husband is still represented by counsel. She did not appear in an unbundled capacity. That means if there's any discussions, you are to go through his counsel. If you're going to be relieved of your responsibilities today, we should probably put it in the order from today, counsel. That way, opposing counsel will know who she should contact on this case. At some point, if arrangements are made, your counsel may come back into this case. But at this point, there's really shouldn't be really any contact from the two of you. I think it would be a terrible thing if one of you ended up in jail. What I could tell you, jail is, though I have visited many times, I have not actually stayed the evening, but I could tell you it would not be a very enjoyable experience. So my goal is to get the two of you divorced, to resolve these issues as quickly as possible, and to have the two of you done with court. That's how I handle cases in my department, and that's how I'm going to handle this case. So if anybody has any expectations other than that, you're probably not going to be happy in my courtroom, because that's how I handle business here. So that being said, I'm going to put the two of you under oath here real quick. And you can remain seating, sir.
You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
All right, ma'am. You had filed some pleadings in this matter. There was a complaint that was filed. There was a TPO that was filed. There was a motion that was filed. And is it your testimony that everything that you put in there is true and accurate to the best of your knowledge?
Okay, can you show me which one that was?
All of these pages that Damon filed.
Okay, there is a portion in there that I filed with Damon. I had won some money, and then it was left in my car that I was going to bring to him, and when he took my car, the money was gone. I no longer have it. So that's the only thing that is not true. I mean, that is not true in what I signed.
But everything else, as far as what you submitted,
Yes,
it is
sir.
your testimony to the court that is true and accurate.
Yes, sir.
I believe, and same question as to you, sir. Everything in what you filed in your complaint, your opposition, your TPO, your representations, that everything is true and accurate.
Yes, sir.
Ma'am, on your TPO that you filed on July 22nd, requesting a temporary protective order against Thomas, there was a paragraph 11. It says, have you ever been arrested or charged with domestic violence or any other crime committed against your spouse, partner, or children? And it says, if yes, when and where. You indicated no.
Correct.
And he had submitted something that you were apparently served in jail. Are you aware of that?
No, sir. I have never been in jail with him for anything.
I believe it was attached to your
It was in
opposition.
1999 in California. It was against a other
Okay, but I thought it was said that she was served while she was in jail.
She was in 1999 in California for domestic violence. That's when he had to go and get her. 1999, correct?
Right. No, 1998, December
I'm sorry,
1998.
1998.
December 1998.
I was married for just a
The
couple
question was whether you were in jail or not, ma'am.
I was in jail, but can I explain?
Well, was it on it?
There was nothing, how do
Were
you
you
say?
not convicted?
No, there was,
Okay.
we were released, there was nothing because nobody did anything, everything was dropped. It didn't even go in front of a judge, nothing.
So
And-
you,
No, was not charged with anything.
I believe
sir.
the language council, have you ever been arrested or charged
I was never
with it?
arrested.
Well, if you were in jail, ma'am, you had to be arrested. They don't just,
They took us to cool us down, is what it was, but they never fingerprinted or anything like that. Never.
Never booked
No,
charges,
never
I should say.
booked. No,
well, there's a difference between being charged,
I'm not
being
understanding.
booked, and being arrested. And the question in there, have you ever been arrested or charged? So it appears to me that she has been arrested, because if you're put in jail to cool down, that's an arrest, right? When you're lawfully detained, correct?
Okay, all right.
So, all right.
Yes, sir.
As to, it appears the marital residence at this point, it was transferred in both of their names, correct? And there is a presumption when you transfer a property, and it's in place in both names, even if it was separate property, that there was a transmutation to community property. So it doesn't appear that that should be in dispute. Is that correct, counsel?
That is correct, Your Honor.
Okay. Do we know if there's any equity in that home?
There may be a little bit, but he believes it's upside down right now. So he doesn't think there's any value, but we can get, as we go on. I mean, this process has been rushed. We haven't done a lot of discovery or anything
Right.
yet.
Well, the court is going to open discovery today to make sure that that's clear. What I'd like to do is get some orders in place so we can have an idea as to where things are at. Obviously, if they're going to get divorced, you need to have an informed decision as to where you are at financially. Do we know if the mortgage is continued to be paid?
He has paid that. He has maintained the payments throughout.
So there's been no missed payments.
No.
Okay. All right. We're probably going to have to get some type of value on that home. Do we know who has the information regarding the loan information from the bank, how much is outstanding, how much the monthly
She
payment
has.
is?
He has some, but if not, it's in his name.
It's-
We can
it's
call
in
the
on
bank.
it, yeah, we
We'll
can.
call the bank and take care of that, Your Honor.
All right, I would like to have that done. The court is going to put some orders in place that I would like certain things done within the next 21 days.
Okay.
The
And
court-
just provide a copy to either
Yes.
counsel or her,
Yes,
correct?
absolutely. The court is going to set this over for a case management conference also, and I'm going to put that out somewhere between 30 days, give or take, and I maybe go a little beyond the 30-day there. As far as the business, do we know if that's still up and running, counsel?
His business
Yes.
is, they currently have one job pending. They've had no income in it. They have 3 bids out. They may get a job in October or November, but right now it's basically pretty stalemate. They had some money in there that was paid, that he got, I think, in May or June, which paid most of the bills, and it's been paying the operators and the supply cost when they've been able to get that. But at this point, it's kind of on a hold right now. And other than that, I'm sorry, what? Go ahead and answer it again.
Is it all right, Your Honor? We do have a job that we started back in near the beginning of the year, or May, and after I started the job 2 weeks later, I went in the hospital, and my operators finished that job in June. I think it was first part of June. The rough grading. They're started back in last week doing. It's a sub base for trails, 6 miles of trails. Anyway, they started back. We're not going to get a billing put in until the end of this month, and it's going through the city. Time it goes through the contractor, the general contractor of the city, and it gets okayed and paid by their pay app Textura thing. It's going to be September. It's going to be the end of October or middle of November before we get any monies in. At that point, then we have all the materials that have to be paid, the operators, the fuel bills, and the expenses out of there, and whatever's left at that point is what my business, my corporation takes in. And this corporation, may I point out, this corporation was in my name, has always been in my name only, but that's it.
Okay, sir, as to the business prior to, it may be a separate property interest, notwithstanding, this court can look at separate property and looking at, providing support for the community. Is it, sir, do you have an accountant who is on the books who takes care of your records for you?
I did have one. Right now, my daughter has been trying to do my payrolls that we have. I couldn't afford the accountant. I can have him work up something, though, whatever is necessary for the court.
I can have that done also within 21 days. Would that be a problem?
Yeah, we can do
within
that.
21 days,
Okay.
we can provide that to them. What
All right.
what exactly,
Exactly.
do you want the
Well,
accountant?
I need to know as far as what
Profit
kind
and
of,
loss, or
yeah, but if they have money in the bank, I mean, I need to know what's, he may not be drawing right now.
right?
And there could be a number of reasons. I need to know why he may not be drawing. If he's not drawing because there's no money there and they're waiting for money to come in, I'd like to know if money's going to come in towards the end of October, how much they anticipate is going to come in versus, how much they're having materials. And, sir, have you been filing taxes for the business every year?
He does file taxes every year.
So you're current on your taxes?
No, I'm not current. I have filed, but I'm not current on the taxes.
Well, let me ask you this. When I mean,
The personal taxes,
I
I'm
mean,
sorry.
as far as with the business, do you file your corporate taxes every
Yes.
year? And so when I say you're current on that, is for 2012, you filed by April 15th of this year. Is that correct?
Yes.
Okay. We should probably go back, at least for right now, 3 years on his taxes for the business, and we can see what's there. Ma'am, he alleged that you attempted to forge his signature and get money out of that business.
No, sir, I did not forge his signature. I did not take money out of his business. And may I explain what happened at that time?
All right, well, ma'am, again, I'm just letting you know you're under oath, so if you
Yes,
tried
sir.
to get money, did you try to get any money out of that business?
No, sir. He had hard money loans. He was in the hospital, and there was hard money loans that was hitting every day at the bank. And I was told and then non-sufficient funds. I mean, this is all documented. Non-sufficient funds were hitting that $99.53.
All right, hold on.
The bank has
Hold on.
everything.
You are here as observers. You cannot be shaking your head. You cannot make any comments, or I will kick you out of the court in a heartbeat. All right? This is a serious matter for these two. This isn't a place where you're cheerleading or anything like that. You understand that? Yes, sir. Okay. Jimmy, if you see anything, you walk them out of here. Yes, sir. And what I said before, this isn't gamemanship. I'm trying to help these folks out and get them divorced and do the best that I can. Having other people sometimes doesn't help because there's a lot of emotions in here, so I'm keeping that out. All right, so ma'am, did you try to get any money out of that business at all?
No, sir.
Did you try to make any payments from that business?
Yes, I tried, but because I didn't sign on the accounts, they would not talk with me, like the hard money loans on his equipment. That was, every day was $99.52 or 53 cents. When that would bounce, then non-sufficient funds of $34.
How much money did you try to access to pay those hard money costs?
I couldn't ask, there was none in there. That's what I'm saying, it was upside down. Every day was going negative.
All right, counsel, your client's representations on that?
He still says he's got the proof, and he's ended up going to the district attorney's office about the fraud.
Well, then he
Because-
should provide that within that same 21 days, any proof that he's showing that she tried to access that information. Some of this information will be pretty easy to find out because you can call,
It's attached to the opposition already, Your Honor.
And
An
they,
exhibit to the opposition already?
I saw some of the exhibits there.
What number exhibit is it?
You mean that since you just come in and she had another attorney
Oh, you know what?
representing her?
I'm sorry, hold on. He's got something stapled. I'll get this to
Okay,
them.
that was-
That's
Okay,
my
all right.
mistake, and I
Same
apologize.
next 21 days.
And then, Your Honor, one other question we have is on the 3-year taxes for the business. I know Ms. Mercer just came into this like within 2 days, probably, but I did send a letter to Mr. Schultze while he was still on the case, offering to return some of her clothes and things at the house. But in addition, when she left the house, she took some of the corporate documents and tax returns were included with that, so we had asked to have those returned, and I never got a response. So you want 3 years of taxes. I don't know if our side can get those within 21 days, because
Okay.
she took some of them. We may have to order them unless she willingly hands those to us, which she hasn't to date.
No, sir, I did not do that. All my papers, all my paperwork, everything I have is at that house, including the paperwork for my business. I do not have any of that, as God is my witness.
Well, if we have to order them, what I'm saying then is she's going to refuse to do that, then we will order them, but it may take longer than 21 days to get those.
All right, to the extent at this point somebody is able to find those records,
Sure.
you should just get them over to the other side so we can have this case moving along. So at this point, if they show up somehow, I don't care how they show up, I would just like them to get in the meantime, counsel, you should probably have your client do a request as quickly as
Well.
possible on those records. Is there anything at this point, ma'am, that by way of at some point, they're going to have to inventory what's in the home, counsel.
We've
I-
already, that's fine, and I've offered, to send a video to do, if they want to come in with the video. The thing is, I don't want these two people in the house together.
Understood.
If you want me to go
Understood.
take a video, I'll be willing to do that as an officer of the court and video what's in there. Counsel can come with me, or a third party from her side can come with me. I have no problem doing that and taking a video of the home.
All right. So, in that regard, I agree that they should not be in the home at the same time.
Correct.
All right. So the court is going to order that within the next week that parties make arrangement through counsel to set up a time. I don't know if we could do it here today as far as a time, or
We can do that, can't we? Make a time to go. She wants to send somebody over, and I can go over, and we can.
Yes, yes, Your Honor.
all right. So why don't we?
The only other question we have on that is there was some property that she also removed, so we need either an accounting or an inventory of that also. So can we also get that within 7 days?
I think we should set that up also. Ma'am, were there some items that you had taken out of the home?
Yes, sir.
Where are they stored at?
Well, my sister was there. She had been living with us. She filled her car and my car. There are still items of my sister and my brother-in-law's things at the house. Those things were taken so my sister could go back home to California. And I took a little bit of clothing. I took my makeup, and I took 2 of my paintings that I had there.
This is going to be a continual, he said, she said, because he has somebody at the house that watched him take out 4 carloads of items. There's paintings. There was at least 6 to 8 paintings that are gone in the house after they left, and he was in the garage when she and her 4 people went in.
Whose
So
paintings were there? Were they?
Community property, I assume.
wouldn't there be?
Before marriage, they were mine that I've had before marriage of 24, 25 years ago, sir.
Well, ma'am, my understanding that the two of you, there was an annulment because you were previously married to somebody, and that had been taken care of, and that the two of you got married in 2005.
Correct.
So,
We got married in 1991.
understood, but there was
And
an
we got
annulment.
a marriage annulled because of his ex-wife.
Well, he was saying
and
that you
he's,
were married at the time, ma'am.
To him?
No, to somebody else. He said your third husband, that you were married to your third husband in California at the time that you married him.
That I was married to both of them? And are
That's
you
what
saying?
he's- that's
No,
what-
sir, that is not true.
Well, somebody ought to.
We can find that out.
I would get the
Public-
annulment. I would get the annulment from California. It's public records, and we'll see as to whether you were divorced or it was annulment because you were married. And again, ma'am,
I didn't. I got an annulment because of his ex-wife.
okay, well,
Why they got the annulment? It was annulled.
well, no, I mean, he said he got the annulment because she was married to her third husband in his pleadings.
Right. And
So-
she's saying something different. But at this point in
I know,
time,
but what I'm just saying is, at the end of the day, there's going to be a lot of he said, she said.
well, we can go back and try and get the paperwork on
I
that
would
too,
try
and
to
she'll
get it
work the
because,
same thing.
to the extent that, all right,
No, he understands that, but he wants, because you guys are both saying
Yeah,
why
before the time
different.
period.
he
understood.
wants them.
There's going to be some things that are going to be easier to verify who's telling the truth, and some things that are going to be more difficult.
Also within 21 days.
I would like, well, and I don't know if you can get that within 21 days, but I'd like somebody to get that.
Okay.
Because
she has
ultimately, there's going to be a lot of things that they are complaining that I don't have, he has it, I don't have, she has it. So that's why things that are easily verifiable, then that would be helpful in making overall determination on this matter. But the two of you have been married since 2005, ma'am. You have an 8-year marriage. You know, you don't get the benefits of a long-term marriage unless you're actually married for 23 years. All right.
I've got the annulment right here, Your Honor.
Okay.
It's filed May 27th, 1993.
All right.
From annulment
Yes,
from Tom.
from him.
And the annulment was from him, but I want to know the reason for the annulment.
Doesn't say on here.
Doesn't
That's
s-
nullity.
Because, can I?
You're
may I
stating,
explain?
you're stating, ma'am, that was because he was married to somebody else that there was an annulment.
No.
He's saying that you were married to somebody at the time, and that's why he got an annulment.
No, sir. The reason of the annulment was when we got married in 1991, he had already got the divorce from his ex-wife, Tina, and that because they didn't have their property settlement finished. So they were still fighting over property. And when that happened, she tried to take part of my home and my possessions, is why we got our marriage annulled. When they fought for many, many years, and when that got done,
Ma'am?
then that's why we got remarried in 2005.
Counsel, can I have my marshal make a copy of that so opposing counsel can have a copy?
Oh, certainly.
I'm just going out on a limb here.
We'll try
I'm
and
not-
find
hold
the
on.
document.
I'm not thinking that, you know, the court in California is going to base annulment on just anything, that you have to have, you know, a statutory requirement that would allow an annulment. So at some point, there's something that's been filed,
A complaint
how,
or something.
yes, that would indicate, and so that's the only page that you have on that, ma'am?
Yes, sir. Mhm. I had all kinds of paperwork in the car when he took the car.
So you're saying that the pictures that you took from the home were yours prior to the marriage?
Yes, sir.
And where are those pictures now?
I have them in my possession where
All
I
right.
stand.
What the court would like to do is make an arrangement that we can inventory whatever she has, whatever he has, and ultimately, at the end of the day, the court can make a determination as to whether it's community property or separate property. But I want to be able to, you know, have an idea as what was in the community home and what we're going to do with things. Other than the pictures, are there other things that you've taken out, ma'am?
Just my clothing, and like I say, my sister was with me at that time to take her things so she could go back home to California. There are still her possessions at the house because there wasn't enough room to put in her car to drive home. Also, to prove that these things were mine before I married Tom, pictures are at the house where he is.
If anybody has any pictures of items, you might as well
We'll exchange those also.
make copies and exchange those. All right, there was a business that you had opened up, ma'am.
Yes, sir, that we did.
He was
yes.
indicating that those items were in the garage from that business when that business closed. Do you have any idea where those items from the business are?
I'm hoping that they're still at the home.
And what do you believe would still be at the home, ma'am?
I had opened a business that we did together. It was going to be our retirement. We had a fudge, gift, and coffee shop. And we were moving everything to the house because he wanted me to stay there and take care of him, and I couldn't run both. When the day that we finished was the day that he attacked me, so everything was at the house.
All right. Do parties have any photographs of that store or that business with the items there? Okay, that should be exchanged. Additionally, somebody should make a list as to what they believe was at that business at the time it closed. And then at some point, we'll have to determine, again, this is a he said, she said. She's saying that it was in the garage and she didn't take it out. And he's saying that it was in the garage and she, in fact, did take it out. And they're both saying that it's no longer there. So, again, we don't need to exchange those here in court, counsel. That should be exchanged within the 21 days. So whatever photographs each of them have. They should do an A-B list as to items that they believe were in the home prior to the separation. And my understanding is pretty much undisputed that the date of separation was July 20th, 2013, correct?
Correct.
Yes, sir.
All right. So within 7 days, parties are to meet and confer regarding getting a inventory, whether it's a videotape or digital camera, whatever it is, and then that we preserve that information, and later on the court can make a determination as to what to do with it. Ma'am, is there anything that you would like to have from that home by way of clothes or other things?
All my winter clothes, my shoes, all of that is at the house. When I left, I only took a couple things out of each drawer. So
Okay.
I didn't know I wasn't going to be going back to my home because I thought, with what was going on.
And her family pictures she would like.
What we can do is, if you'd like, when I go or my assistant goes to video the house, she can get it can be exchanged with whoever comes over on their side that day.
And again, if there's any, women's clothes, that kind of stuff, I don't see any reason why.
He's already offered, so it's
Everything,
fine.
anything and everything there as far as clothing or personal hygiene items, her pictures. I mean, she's got photo albums from 40 years. They're not mine.
So we'll have that ready for her.
And I would probably somewhere in the home, whether it's a living room, a bedroom, or something, you should probably have all that stuff. It should be in the same condition it was back on July 20th. I don't anticipate that somebody would go in, though I've had cases like this where people cut up their clothes and destroy pictures. And I've had people your age doing the same thing. So the court order is that neither party is to destroy, damage, or discard, get rid of, throw out any of the property that is either community property or potentially property of the other parties. All right, as to, I don't know if counsel, I would like to, because right now I haven't seen your client's financial disclosure form. I don't know as far as, and I think I can address it better on our return date when I have some information regarding, what they have in the bank, both personally, any credit cards, any savings, bank accounts, all that should be exchanged within this 21-day period. If somebody's claiming there's a community debt on a credit card, you need to provide the backup. You should probably provide the backup, I would say, at least going back a year. I think that would be sufficient right now, since probably a year from July 20th. That should be provided to each of you. If there's any retirement 401ks that either one is claiming it's community property or community debt, what the court would tell the two of you, if you omit an asset and if you don't disclose that on your financial disclosure form, and later you find out that in fact somebody was hiding something or they just omitted it, I could actually award that to the other side. So what I'm telling the two of you is that you need to be very open and honest as to what property is out there, recognizing that if you're not, even if it was a separate property, I can now make it separate property of the other person. You understand that, ma'am?
Yes.
You understand that, sir? Okay. So any claim of a community asset or community debt, you're going to have to disclose, list it, and then as far as if there's a credit card, let's say Bank of America credit card, and it has a $5,000 balance on it, I need to know how that $5,000 balance was occurred, how that got there. It could be because you need gas in your car, that you need, to go to a grocery store. But the actual statement, and you can get those online, the actual statement will show what that was spent on. So I need that information. Other than that, what I'd like, as to, the court is going to put a no contact order in place. I'm going to dissolve both of the TPOs that they have, because I'm now control over this case. What I would tell the two of you, I have my behavior order and my no contact order. If you violate my no contact order, you could go to jail for 25 days as contempt. I don't want that to happen, but I'm telling you that if somebody is misbehaving, that I'm not looking at age as a factor, and I would put you in jail. All right, the other thing that I'd like counsel to do, since I have everybody here, counsel,
Yes.
at least right now, I'm not inclined to take the husband out of the home. Based on his medical issues, I think at this point it'd probably be easier for him to stay out of to stay in the home. But at the same time, I need to provide for the community, because they are married and they have been married for 8 years, and whatever funds are available, to the best that I can, and it may be limited, I'm going to try to provide for the two of you and see what we can do there. What I'd like to do is take a recess on this and have them have a discussion as to what community funds are currently available. There may be more available in October when he gets paid through the city or somewhere else that we can access, and figure out what we're going to do as far as providing for the community on a temporary basis.
Your Honor, the only thing, and I don't know if you had seen it in our thing, is there's an issue with gambling and marital waste, which is I wanted to bring up also because we may not be able to get all that information for a 30-day return hearing when you want to know all this. But when I spoke to her other attorney after the TPO hearing, she had in the last week of July won like $14,000. So she's still gambling over like a 7-day period of time. So there's still that issue. So now she's coming here and saying, I'm broke, I'm penniless.
Well,
But there's
as
a
to
huge
the
issue with that.
$14,000, I know not where that $14,000 is. I understand. There's a representation that it was in the car, and then he took it. There was also issues. I don't know how many community cars there are. There was an issue that he was indicating that there was a vehicle that was being, I guess, modified to allow him to drive the vehicle. That's probably something that the parties should discuss. As to right now, ma'am, are you fine if I put in an order that there would not be any gambling?
Yes, I'm fine with that.
They would gamble
It can be
together,
a
Your Honor.
mutual.
Well,
it
I
can
could
be
put
a
in
mutual order.
mutually inclusive order that neither of them gamble. I mean, right now they don't have a whole lot of money.
Well, Your Honor, it's our contention that he's hidden some funds. That he has hundreds of
I
thousands of
understand, but I'm just trying to get us through on a temporary basis, and some of these other issues are going to have to be, fettered out through a trial. So, that being said, what the court would like parties to do, and again, our return date is going to be, what's today? All right, counsel, I could put it on the 15th, or we could go out a little bit beyond that. My intention would be I'd like to have enough information back where I could, put some temporary orders in place today and revisit them when I have additional information. So I don't know if that date is.
The 15th of October, Your Honor?
Yes, so I mean we could go out maybe another.
I have the 29th.
That might work out better because I may need some more time to get some.
Okay.
Well, except she's the one that doesn't have any money, so she
But
would
what-
We're
prefer
taking a
sooner.
recess right
Okay,
now.
what I'd like to do is right now at least have a temporary order in place, have them discuss what's available to the community, and then come back on the 29th and revisit those items when I have additional information and make additional orders. And again, on a temporary basis, this board is, I have access to everything, community property, separate property of these parties to get us through on a temporary basis. And under, I can't even remember the section, but during the pendency, this court has the ability to do that. So
Madam Clerk, did you say September 29th? Because I think
October.
that's.
October
I'm sorry.
29th.
I was like, that's a Sunday.
And the time would be
9 a.m.
9 a.m. You know what? Let me look at my calendar real quick. I may override that, by the way.
Okay. I'll get you a list. No, just whatever was
By the
for
time
right now.
computer A goes to computer
We're
B,
gonna take
tell
a break.
computer C, tell computer D and all the cards that it's been dissolved, can take a couple.
My preference, council, it would be October 28th.
Okay.
It's on my calendar calendar. I don't have anything else set right now. I don't think I'm going to have anything set. And that way, if we needed to, have 30 minutes, an hour or something, you're not on my motion calendar and I'd have time to address it. So I think that would be the better time to put it on.
What time?
At 10:30 on October 28th.
That's fine.
In the meantime, I'm going to have parties go into recess, have a discussion regarding temporary orders. To the extent that you put something in place, it would only be in place until October 28th when the court can readdress it. And to the extent that you can't reach some type of agreement, the court's going to entertain a short argument as to what we should do to get us through the next 6 weeks, okay?
How much time you want to give us since it's
You
on
can,
switch time?
I have a hearing at 11:30 that I'm going to be here probably at least an hour. You can take as much time or little time as you like. But in the meantime, if you get to a point where you have something, I will interrupt that other hearing and recall the case.
That's fine.
Okay?
Thank you.
All right.
Thank you.